We'll be upstairs, all good. Oh, and we're on.
Right.
Good morning, good evening, and hello.
Right, Mr. Ryan, we are live.
We are
Welcome
live.
back. Disqualified Dad. Here we go.
Here we go. Here we go. It's almost the end of the year. Yeah, it's ridiculous how fast this year has gone past. Maybe I'm just getting old.
We are encroaching 2025.
Thank you.
Very fast. We are
Yeah.
encroaching it very fast.
Mm.
In my mind, the way I'm operating currently, I am already in 2025. I've set my targets. I've set my goals. I've started the daily habits, the daily actions. I went gym yesterday. I went gym today. I'm pushing it. I'm pushing harder, and I'm building up. I'm already started. I'm already in 2025.
You are an inspiration to us. You really are. I went to Costa yesterday. I went again today. That's just me.
Okay, fair enough.
That's how I roll. That's how I roll.
Listen, you're living it large. Listen, you're living it large. Some of us are in the trenches. Do you know what I'm saying? You're living it life large, bro. I'm in the trenches here. We're surviving. We're battling.
I appreciate that. I'm going to step off camera for a minute because I just need to put the comments on so I can see them. Hang on a sec. Sorry, everybody.
Yeah, it's all good.
There we go. Now I can see.
Hungry Hippo, welcome back. Yes, of course you can ask questions.
Yes, of course you can. That's what we're here for.
That's why we're here. We're here to help and support. So drop your question in, and we'll bring it up.
That's what we're here for. Yeah. So as I say, yes. So we'll wait while we're waiting for this question. Yeah. So 2025 is nearly with us, and we've got an exciting one, haven't we, chap? We've got a very exciting one ahead.
Absolutely.
Yeah, we've got a lot going on. Aside from from my point of view, from the there's nothing normal about what we do, but apart from obviously the working with the clients, obviously, who are valued and cherished. So we'll continue to do that day in and day out. But yeah, we've got some new stuff going on, which we're going to chat about over the course of this. But yeah.
Absolutely. Before we go into that, Mr. Ryan, I just want to highlight to everyone, look, for 2025, so one of my goals is this, which I might as well put it out there now. I'm going to aim to, I have now, where I move around sometimes, or where I move about, some Sundays I can't make it, or we must have missed the odd one here and there. I aim to be here every Sunday, 8 o'clock. Mr. Ryan, more than likely, most Sundays he'll be with us. He's been pretty consistent for the last few weeks, so more than likely he'll be with us. And add to that, I might even, because of the way I'm setting up and moving forward, I'm ramping things up. I might even be hitting a Wednesday evening show just on coaching, mindset, to help people get through this trauma. Now, look, I know there's a lot of mindset coaches and fitness coaches, and they all tell you this. Listen, I'm talking on a normal grassroots level, practical steps of survival, not how you make your first million, nothing like that. Not even how you make your first half, nothing crazy. We're not going mad. I'm talking about practical level, everyday guys, what they can do, how they survive, how they can better themselves, just to try and keep that positive mindset going. So look, that's what we're going to do. Sunday, we're going to be here every Sunday, 8 o'clock, even if it's for 45 minutes or so, just to make sure we keep that consistency, and we're there to answer questions, just keep the knowledge, information, and the hope out there to support people. So that's the first goal for 2025. Sunday night, 8 o'clock, I'll be here, whatever happens. Ultimately, and more than likely, Mr. Ryan will be here as well to support you. So that's the first thing. Right, Mr. Ryan, do you have anything else to add? Because the questions are already racking up.
No, the questions are racking up. Let's have a little tackle of those. But I think you're right. I think a open coaching session would be valuable.
Yes, and
there's definitely value to that. And obviously, we'll be integrating coaching more in these chit chats as the months and the weeks and the months roll by. But yeah, no, I think it'll be hugely valuable. Good point. Good point.
Absolutely. I want to add to that as well. For those who don't know, Mr. Ryan also does a lot of counselling as well. You see the sofas behind him there. He does a lot of counselling, a lot of one-to-one. So he has a lot of experience. So he might even be jumping on some of the coaching on some of these Wednesdays. But I'll be bringing a variety of coaches in, whatnot, including myself, to try and cover all of that and all aspects. Right, Mr. Ryan, let's jump into it, because this is...
Here we go.
They know we're here. They're here. Words out, we're on. Right, Felix, Mr. F. Let's say there's a potential custody issue and also a financial issue in the works, pre-court but expected. Hold on.
Right.
Follow up. Should I take my ex to the courts for 50-50 for my child? Can the courts direct that the financials be resolved prior to custody? For example, I am not legally married, but share a property with my ex.
Okie doke. Here we go. Where you're running financial proceedings and child proceedings are running side by side, this presents the court with something of an issue, particularly if the child proceedings are not obvious as to how they're going to unfold. If there's a distinct possibility that 50-50 is going to happen, the courts are very reluctant about concluding a financial matter until they understand what's going to happen with the children. And I'll give you a very real example of that. I was in court very recently, like about 10 days ago, and we were in a financial matter. And we were talking with the judge, and we mentioned to the judge, obviously, that there was a child matter also ongoing, which is highly likely to result in the children essentially spending most of their time with their dad and then having a contact arrangement with their mum. The judge said, and it was an interesting point, the judge said, I am not prepared to progress these financial proceedings until such times as I get to understand what is happening with those children, because I could make a ruling, I could divide the assets in this marriage inappropriately because of how those children sit. So I'm not prepared. So what he actually did was he essentially suspended the financial proceedings until such times as the child proceedings have finished, which is probably going to be about April, May time, maybe June, and then he will reopen the financial matter. So courts, so to answer your point, if you go into the court and you're going to apply for 50-50 and you've got a financial matter running alongside it, you will present the court with a problem because they don't want to divide the assets until they really understand what's going to happen with those children. And I think what I saw the other week, i.e. a judge saying, I'm going to put finances on the back burner until I know what's happening with the children, I think that's going to happen more often.
Yeah, I mean, look, from what I understand and what I've seen and experienced as well with the financial element, the problem is again, if we go back, I'll strip it back to the basics again. The resident parent holds the cards, including the financial ace card. Remember that. Keep it, as far as I'm concerned, keep it simple in your head, yeah? Because when people start collating and what's the word I'm looking for? Diluting like financial child and can this all run cyber? Everything is connected. Resident parent holds the power. Resident parent has the children. Children need housing. Resident parent is looking after the children, and the resident parent needs housing. Financial will all depend on that. So remember that. Like I said, we're going to come out with this 10 commandments of family court, things that you need to remember. One of them is going to be this. So I'm just saying it now. Yeah. Resident parent holds the cards. It will definitely affect the finances ultimately.
Without a doubt. Yeah, without a doubt.
Right. Next question, Mr. Hippo.
The hippo who was first out the trap.
Absolutely right. Last ICFA contact session, 9th of December. Been told to find contact centers. Have found. Told CAFCAS and ICFA. Haven't heard anything since. Feel left in the dark. Ain't heard anything since. What does he do?
He waits. The reality is, I'm not surprised you haven't heard anything because unfortunately you've hit the Christmas close down. The courts are closed currently. They've been closed for the most part since Friday the 20th of December. CAFCAS tend to also close down for that period of time. The courts won't formally reopen until the 2nd, and CAFCAS are also likely to do the same. So the reality is, it's not that they've forgotten about you, it's that they're not there. They're on holiday. And so unfortunately, the downside of being Christmas. So you've got to wait, you've got to be patient. What I suggest you do is on the 2nd, you send an email to CAFCAS, just jogging them a little bit, giving them a little bit of a nudge and just asking them what is happening. But that's the downside, unfortunately. The world closed for I think the 2 weeks.
Yeah, look, that makes sense. It makes complete sense. Christmas, holiday period, most industries are, unless other than the shopping industry, all other industries are closing down, including family court industry.
We didn't.
Hence, it's a difficult time for fathers. That's why we held that stream on the 25th, which I thought was a very positive stream. I don't know if the viewers found it positive, but I was charged up after that. I'm still charged up after that stream. So look, go back to the lessons that we talked about there. You need to exercise patience. Keep your game plan clear. Do not let these setbacks deter you from the main mission. So Hungry Hippo, stay hungry. That's my message. Stay hungry and stay focused.
True.
Right, Mr. Majid, right. I need to apply for my transcripts as there is a lot of dodgy decisions being made by the judge and Kafkas. The transcript couldn't be found and then dismissed.
Okay, and then I think he rolls on to ask then about how much transcripts cost, etc., etc. All right, let's talk about transcripts.
Okay, talk about transcript. Okay, here we go. Look, so he's followed up from that saying, how much do transcripts cost? Being told if on benefits it's free. And then he's got another follow-up question. We'll jump into that in a minute.
Okay, we'll jump to that in a sec. Let's tackle transcripts very quickly. Just so, for those who don't know what a transcript is, every hearing that takes place in a court is recorded. That is a requirement of law in order that they have a point of reference. You are entitled to apply to receive a copy of the transcript of that hearing. So what that basically means is that the recording is handed over to somebody, and that somebody types the recording up. So what you get is a written version of every word that was said during the hearing whilst you were in there. You're entitled to apply for that. Now, the next question is a bit more tricky because it says, I've been told they're free. They're not. Transcripts are prepared by an external company. They are not. It's not a court function that does a transcript. There are half a dozen or so transcript companies in the UK that are approved by the court who are allowed to get access to court audio recordings. And when you apply for a transcript using a EX107 from the top of my head application form, you are asked to nominate which of the half a dozen transcript companies you wish to use. And then what they do is they receive your application form. They receive a copy of the audio recording from the court. They very quickly measure, because it boils down to how long the audio recording is as to how much they're going to charge you. They measure how long the audio is, and then they send you a quote. A 1 hour hearing, most of the transcript companies are pretty similar in terms of their cost. A 1 hour hearing is going to be between £200 and £300. They're going to charge.
Nick, for real.
Yeah, I mean, I transcribed a number of years ago now a 7-day fact find, and I had the whole 7 days. It cost me £5,500 for that transcript, but I needed it. I needed it because I needed to demonstrate a point that had been made during it, which didn't feature in the judgment of the judge. So I needed the transcript. So yeah, they are not cheap. I have never been told that you can get transcript for free if you're on benefits. That's never happened, and I've ordered, well, probably hundreds of transcripts over the years, and unfortunately I've paid for all of them. So that is
okay.
The way.
Perfect. That answers that question. I just want to touch on that now. I want to touch up on that again. One of the 10 commandments of family court: trust no one, believe nothing, don't listen to hearsay and gossip. Yeah. Check out everything. Check out the facts. You hear loads of these sort of things, and it turns out it's complete opposite. Do you see what I'm saying? Like benefits is free, complete opposite. So look, you're doing well. And Majid, I hope you're keeping out of trouble here, by the way. Right, Majid's got a follow-up question. Yeah.
Mm-hmm.
Doing courses and hoping to have 3 reports from professionals.
Okay. Always, it's. I mean, we don't know the circumstances of your case, Madge, but it's always positive if you're doing something to better yourself. And Farouk is far better placed to talk about this than me. But if you're doing something to better yourself, that is always a positive, providing that the course you have chosen has some relevance to what it is you're trying to do, has some relevance to your circumstances, and is a real course. The internet is full of rubbish. The internet is full of, give me $25.99, sit and watch this utter rubbish for 60 minutes, and then I'll let you print out a certificate. They are not worth spit. And I've had those courses dismissed more times than I can remember in the family court. So if you are doing courses, make sure they have some relevance to your situation.
Well, I just want to touch on a couple of points what you said, Mr. Ryan, and I just remember the earlier point which I forgot. Right, that transcript that you had made cost. I just want to say that again. 5.5 grand just for a transcript, not the overall case, just a transcript part of the case. Now, I want that to sink in for a minute. £5,500. Everything connected to family court is money, is cost. Hence, if you cannot afford these costs, you need an ulterior option, which me and Ryan are going to talk about more and more. We've been talking about it for the last few weeks: a roadmap, a guide, a GPS. Like I said, you can hire a driver to take you on a journey, or a chaperone to take you on a journey so you don't get lost and he gets you through all the danger and trouble. Or guess what? You can buy a GPS. That's the other analogy I've come out with. A GPS will be a lot cheaper and you take yourself through that journey. That's the analogy that we keep talking about, push it out there. You'll see why soon. And also, now I've forgotten my second point. So if I remember, I'll mention the second point after, but it's gone now, forgotten. So I imagine, I hope you're keeping out of trouble, and also stay focused on your mission, on what you're doing. Yeah, don't get involved in other things and whatnot. I know you get distracted very easily, Majid, but focus on the eyes on the prize. Remember that. Right, Mr. F has come back with a follow-up now. Right, let's look into his case. The reason why I ask is that my ex is claiming that she's struggling to find accommodation. So I would think the courts would suggest that the house be sorted so the resident parent is sorted before cost. I would have thought so, but he's got more. He's got more before we jump in this, right? In your example, you used the father as potentially having majority custody, so the judge suspended the financials. My situation is the opposite, where I want 50-50. She's claiming she does not have suitable housing. Can the judge potentially do the opposite and progress the financials given her alleged situation?
I'll answer that very quickly. A family court judge will not knowingly allow children to be homeless. So if he or she deems that there should be some sort of interim solution put in place while we progress the financials, like allowing mother to be in the house, father to be in the house, mother to rent a house or whatever, he or she, the judge will do that to safeguard the children. Simple as that.
Yeah, I think that would, I can see that happening, definitely. Wow, 300 quid. That's insane for a transfer. Can you request certain dates?
Yes, when you fill out your application form, you have to put the date of the hearing. And if the hearing was multiple days long, you can allocate which date or day you specifically want your transcript from, because you may not want all of it. You may just want the first day or the last day or whatever. So yeah, you can narrow it down. £200 to £300 is about the quote for 1 hour's worth of audio recording.
Right, we've got a good one here, Mr. Ryan. Got a juicy question here. Right. Ex spat on my new partner outside courtroom and has been arrested. Section 7. Are you drinking on the job, Mr. Ryan? Are you?
It's Coke Zero.
Are you boozing on the job here? Like, trying to give out a good impression here.
I'm wetting my whistle. It is Coke Zero, and it's horrible.
Right. Ex spat on my new partner outside courtroom and has been arrested. Section 7 recommendations. Kids live with me and children wrote letters to judge asking to live with me. Sounds good. How will final hearing go?
Right, okay. How will the final hearing go, Mike? All right, get yourself a pen, because at the same time, I'm going to give you the lottery numbers for this coming Saturday. The answer is I can't predict how the final hearing will go. What I will say is that you do seem to be, from that very little short commentary you've given us, you do seem to be in a very strong position. If your ex spat, which is a disgusting thing to do, but if your ex spat on your new partner outside the courtroom and has been arrested as a result, if the Section 7 recommends that the children live with you, if the children have reinforced that Section 7 by writing to the judge to say that they would like to live with you, then currently, if this was poker, you are holding 4 aces. The final hearing, without knowing the rest of the detail, because in the middle of all of that, there might be a right mess. But at this stage, reading from the outside looking in, the final hearing looks pretty positive. And I think you are highly likely, given what you've said, to leave with your kids.
Yeah, Mike, it's looking good. Stay focused, eyes on the prize. Again, see your mind. You see, even though this is what I'm talking about, the mindset. This is like Mike's clearly in a very strong position for success here. But you see how your mind can play games with you. You see, this question tells me he still has doubt.
Mm-hmm.
Do you see what I'm saying? Mike, when you go into your next hearing, Mike, I want you to go in believing that you are in a strong position. I want you to go in with that positivity, with that mindset, that subtext that you're going with the subtext that you're going to win. You need to manifest this a little bit. I understand that because the mind plays games with you. You start overthinking. Overthinking that leads to an overreaction. You don't want that. Stay focused, stick to the game plan, eyes on the prize. Right, we'll jump back to, let's jump back to what Mike's commented to a follow up. Let's jump straight to that.
Yeah,
Judge said to X, unless she comes up with something monumental with evidence at next hearing, children are coming with me. Well, there you go, Mike. Just hold on to that.
I agree with that.
Hold on to that, Mike, and focus on that.
Mm.
Right, we're going to go back to Majid. Right, let's go back
I'm going to say this to Mike before we close Mike out. Mike out, very quickly. Mike, go to your next hearing. When you go to your next hearing, do not walk into that courtroom with a face smug. Do not walk into that courtroom with arrogance pouring from your body, because you may get a different judge for a whole series of reasons, and he may have a totally different view. So go into that courtroom with your children's best interests at the forefront of your mind, so that you can say to that judge, and let's trust it's the same one, but if it's not, it's a different one. And you can say to that judge, I am here because it is in my children's best interest, nothing to do with me. It is in my children's best interest that they live their life with me. That's the way forward. We wish you the best.
Okay, that's a very good point, right? So, guys, I just want to clarify. So when I say going with the belief, you're going with belief and hope, child focus, not cockiness and arrogance. There's a difference, yeah. So, and listen, play the game, as I keep saying. Don't, like you said, don't start smiling and start rubbing it in. Yeah, you don't want that. And the key is, again, one of the 10 commandments of family court: eyes on the prize, focus on the children, child focus. Your energy should be child focused. Your subtext should be child focused, because that's what will come out. If that's in your intention, that will come out in your body language and in your words. That's another commandment of family court. I'm giving them away. I'm giving loads away today. Right. Let's go back to Majid. Let's wrap Majid up here. Thank you for answering the question. Yeah, banned from reapplying, so I'm doing the work visa to Australia. New goals, experience much more needed. Vitamin D. Good idea. Listen, go out, get some sun, clear your head, get positivity in your life. This is good. This is good. New goals and ambitions, always good. Reapplying in 18 months as I got banned for 2 years, so I've got work visa in Australia, so making the most of the time. New experience, so much with vitamin D. Absolutely, go for it, Majid. It's a good idea. Right, let's go back to Mr. F. Thanks for clarifying. Sounds like I'm screwed either way. How can I apply for child custody without potentially being kicked out of my home? Or I assume that that's the risk I have to take.
That is the risk you have to take, I'm afraid. Family court is lots of things, but the one thing that family court is, it is a game of poker. And so, you have to play. You have to be in the game in order to win the game. So, unfortunately, because you are running and we don't know the details, but because sounds like you're running a difficult family home situation, you are going to need to get into the game in terms of a child arrangement in order to try and level up the playing field. That's where you've got to go.
Right, he's got a follow-up comment saying, seems like a catch-22 because then I would be homeless or have to rent, which means making it even more difficult to look after my daughter.
Yeah,
right.
Point.
Yeah, what I want to say, Felix, is that just so I understand the situation, she's not homeless and particularly bad. Right, what I understand, just clarify this, Felix. Are you both living in the same house while she's looking for accommodation and you're the main carer? Is that the vibe that I'm getting? But obviously, you're going for child custody and financials, and you're worried, obviously, child custody, financials will be put aside so she can get child custody, and then she'll have the advantage on the financials. I'm presuming that is what your concern is. but are you currently living together because she doesn't have a place? She's in her parents' house. And who has the child? Do you have full? Are you the resident parent effectively? Are you the full-time parent? Clarify that. No, she's the main parent. She's resident parent. Okay, you just clarified that. Okay, well, let's follow up with Felix. All of his comments, right? Right. So he's then said she's not homeless or in a particularly bad housing situation. She has moved back into her parents' house. Bloody hold on. She's not homeless or in a pretty bad housing situation. She has moved back into her parents' house. And sorry for the scattered diet. There was a character limit. Yeah, okay, no worries. And what he's also said is this is the key factor here. She's the main parent, whatever that means. No, not resident. I have my child 3 days a week. But someone would still be okay. So until it goes to court, there's no clarification on who the resident parent is effectively.
Yeah, but if it sounds like, and I'm just filling in gaps which I may be entirely wrong, but it sounds like the wife is potentially saying in the financial proceedings that her being with her parents is inappropriate for whatever reason. Perhaps it's overcrowded, and she needs to be back in the family home because that is in the best interest of the child or children. That is a tactic, that is a strategy, that is a gameplay that is run time and time again in the family court. You need to dismiss that strategy by saying she's in a parent's house. She's been there since X, whenever X is. It's not ideal, but it's working perfectly well. And if she returns to the family home, thanks, there you go. So if she returns to the family home, you will essentially be homeless, and the court will be very uncomfortable with that. They're not happy with the fact that possibly they're in an overcrowded situation, but the court will not knowingly put you out on the street just so mother gets to be more comfortable. That will not happen.
Yeah, that'll only happen if you're me for 2 years
That only
homeless
happens
on the
if
streets. Now, Felix, I've got another one for you now. This is where you got to play the game, yeah? I don't know how big the property is you're living in. I don't know how many empty rooms it's got. I don't know if it's just one room or whatever it is, yeah? But what you can do is this. The court are more unlikely to throw you out the home, or let me say, forget throwing you. They're more likely to not allocate the property to say her. Firstly, she's settled into her parents' home. She's safe and secure. But if your property had other people living there now, short-term tenants, other friends who have moved in for the next 6 months, you've signed a contract for very little money, for argument's sake, you're not earning money out of it. You've got a contract with a friend who's staying there for £100 a month. Like, do you see what I'm saying? You've got a 6-month tenancy agreement. He pays you £100 a month for something. If there are other people living in the property now, the judge is less likely not just to make you homeless, but other 2 or 3 or 4 people that might be living in the property, which you have tenancy agreements for in the meantime, because you're struggling financially. The only problem is, you can say if you have one room, your daughter comes to, the only problem this would then bring is, with the child custody now, where you have your daughter 3 days a week, they could counter and say it's unsuitable for you to have her 3 days of the week because you got a tenant. That's the only problem. So unless it's a family member who is also a tenant, say you had one tenant in the house. So let's say it's a 3-bedroom house and you had one room sublet. That's it. The rest of the house is still suitable for you to have your daughter and child potentially. Would that be a better idea, would you say, Mr. Ryan?
It is an option. Would it be a better idea? I don't know, but it's an option that you do run, and you've just flagged it there. You do run the risk where the court might then entertain the tenant as being a safeguarding risk for the child because they don't know who the tenant is, and then suddenly they say, well, actually, no, it's probably not safe for the child to be in the home at all. So it's a very difficult one. The whole scenario of who gets occupation of a family home is difficult. Is difficult. So there you go. He's telling us now. So your parents live. So it's a multi-generational home. Then Felix, your parents live there with you, and then obviously you have the child.
Perfect.
By the looks of things.
Perfect.
The likelihood of the court disrupting that is very, very, very low indeed.
Yes. So that this is what I'm talking about. You got to play the game again, like Mr. Ryan said. This is like a game of poker. You have to play. There is a risk. You might win, you might lose, you might get your money back, you might break even. There are all sorts of possibilities, but you're in the game, you have to make decisions, you have to roll the dice. Now, Felix, that conclusion again, your parents living in the house, there's family members living in the house, that they're not a risk ultimately compared to a normal tenant. So that is the perfect scenario, I think. Yeah, from my angle, that is the perfect scenario. Your parents living there, the judge is very unlikely to make you and your parents, your elderly parents, homeless at the same time. Yeah, so perfect. And here we go. That's great to know. Thank you, parents. He's covered that. Listen, and there you go. Thank you for clarifying. No worries, Mr. F. You're welcome. Right. Little thank you, little positive message from Mr. Mez. Thank you for clearing up, Jack. Much appreciate your time and all the efforts for us fathers. Absolutely. We're here for fathers and the odd mother who might be a non-resident parent as well. So we support everyone. We support the whole family unit here, yeah? Remember that. Extended family, the whole family unit. Right. I need to go back now with Mr. Couple. We've done that right. There you go. Mr. B, Mr. Dan. I recently went to court, I presume, for my FDR in which X wanted Misha order and tried everything, including a screen in between us. Judge wasn't having any of it, but I got destroyed on percentage, 20% of house.
Right, let's dissect that. An FDR, financial dispute resolution. So this is halfway through the process in finance proceedings. An FDR is a hearing that is set up very deliberately to see whether the parties can agree something between them. And if they can't, then it goes forward to a contested hearing. So what has happened here is that the wife in this instance has tried to force the court or encourage the court to make a measure order. A measure order means that whoever is in the family home can, and it could be mother, it could be father, it could be wife, it could be husband, can stay in the family home until the youngest child, usually is 16, sometimes 18, and the house is essentially ring-fenced and protected for that period of time. And it's in order to safeguard the well-being of the children. Courts are uncomfortable. Courts used to throw out measure orders like sweets many years ago, but now they're uncomfortable with measure orders because invariably they leave one party, i.e. the person who's not in the house, financially compromised, because often they're tied into a mortgage, sometimes for 10 years under a measure order. If the youngest child is only 6, they can be tied into a mortgage for 10 years, and obviously it compromises their ability to get a mortgage for themselves somewhere else. So the court is often uncomfortable with measure orders because they don't find them particularly fair anymore. So what's happened in this instance? Mother's tried for a measure order. The court has said, no, we're not having it. But father has ended up with a 20% share of the house. Now, I have to assume, given that it was an FDR, that the father somewhere, either directly or indirectly, agreed to that 20%. Because had you not agreed to that 20%, the court couldn't have granted it because it wasn't a contested hearing. You've actually gone forward. But you have to accept the fact that if you go forward to another hearing, you're picking up all the legal costs for another hearing. And if you've got barristers in the house, that can run to thousands. And there comes a point in financial proceedings where you think, what am I chasing versus what does it cost me to win it? And there aren't many, and I can assure you of this, in 16 years, there aren't many occasions where the value of the prize warrants the fact that you spent thousands of pounds chasing it. There are very few occasions where that happens. What often happens is you break even by the time you've paid off your legal costs, or you lose money. And that is the difficulty of financial proceedings. So sometimes you do have to kind of get sensible and say, well, look, it's not ideally what I wanted, but I'll take a cut at this point. I'll agree at this point, because at least I'm not going to spend any more money. You've got to cut your losses at some point. The other issue that's worth flagging at this stage, and I'll talk about this in terms of financial proceedings, is invariably one party in financial proceedings could have legal aid because they've convinced the legal aid board that that they've been domestically abused. Consequently, they're entitled to legal aid. Here's the problem, and here's the thing that lots of solicitors don't mention to their clients when they have legal aid in financial proceedings, and it's called a statutory charge. At the end of your proceedings, when you, with your legal aid budget, have just won £10,000, £15,000, £50,000, Unfortunately, the statutory charge kicks in and you have to pay back your legal aid out of whatever you were awarded.
Ah.
And there are so many people who are totally unaware of that. I've very recently been in a financial proceeding where the one party, it doesn't matter if it was the husband or the wife, but one party was totally unaware, and accepting the fact that that party wasn't represented by me, totally unaware of the fact that they were going to have to pay back their legal aid. So she declared the fact, well, that's just giving it away, but she declared the fact that she had her solicitor declared that she had spent £19,000 on legal aid. And then the court awarded her £15,000 as part of the divorce. She's lost £4,000. Because she didn't know. She didn't even know she was going to have to pay it. So she's left the court with a £19,000 bill to pay back on her legal aid, but she's getting £15,000. So her comment was, well, it's all right. I'll just get the £15,000 and I won't pay legal aid. Here's the catch. You don't get the money. The £15,000 is court ordered to go to your solicitor, who is required by law to pay legal aid before they pay you. That is the requirement. So that lady left the court owing £4,000 and earning nothing.
Okay, so listen, just to clarify though, I was under the impression, or as far as I saw it, like you can't get legal aid on a financial order. That has to be paid from your own pocket.
You can get it if you declare domestic abuse. That's the only reason you can get it. If you say I'm a victim of domestic abuse, including financial abuse, you can get legal aid. It's not guaranteed, certainly not as guaranteed as in child matters, but you can get legal aid. But unfortunately, it comes with this catch, and the catch being you've got to pay it back. So essentially, you're not getting legal aid; you're getting a loan.
Yeah, basically, look, they're again, like I said, it's there to exploit all parties to generate money.
Yeah.
Unfortunately, right. Let's move along. Right, Mr. C. The irony: a tenant is deemed a potential safeguard and risk, but mum's Tinder boyfriends never are.
Yeah. I accept that point. No, I accept that point. One party, it doesn't have to be mum; it can be dad as well. They roll out with new boyfriends, new girlfriends that that they've picked up on the street. And before you know it, those new boyfriends or girlfriends are being called dad or being called mum, and they're engaging with the children. And there's no safeguarding. Nobody says, well, hang on a minute, let's just check out who they are. And I have a big issue with that. I've had a big issue with that for the 16 years I've been doing this. And I have insisted on a number of occasions that we do a safeguarding check on the other party's new partner, because I think it's appropriate. But yeah, so I take the point on that one. I take the point.
Thank you for clarifying. Right, Mr. D. Mr. Dean, mother who is resident parent has 2 referrals made by nursery. Right, let's start again. Mother who is resident parent has 2 referrals made by nursery and then primary school a year later, where child disclosed she's being hit by a mother. Why would CAFCAS give this little attention?
The answer is I don't know, because the way you've written it. If mother has got referrals where she has physically chastised the child, and that has been independently verified by either nurseries or primary schools, then that should be a major issue in the midst of the family proceedings, and that should be pursued certainly by CAFCAS. They should be pursuing that because that's part of their own domestic abuse policy to pursue physical chastising of children. So I can't answer that, and I'm astonished if that is the case without knowing the full circumstances of it.
Okay, fair enough. So yeah, if you can give us more detail, we can try and follow up on that. Right, Felix, in a separate question. I understand FC is messy and my ex can make allegations of abuse. Do the courts accept these without question, or does this need to be backed up by hard evidence and not just he said X, Y, and Z?
Allegations in family court will always have to be proven at some point, and the onus is on the party who makes the allegation to prove it is true.
Okay. And where is the line drawn for evidence being accepted for these allegations?
It's driven entirely by circumstance. This is just free advice, Felix. It's driven entirely by the circumstances. Sometimes the court will direct on what evidence they will accept. Sometimes you can push evidence into the court using witness statements and position statements. So it's each case is different as to how it is evidence is accepted and what is accepted.
Right. Well, what Cossip has asked is, why is the same not done regarding legal aid for child-only cases?
Legal aid for child-only cases is not paid back unless the original application is challenged by one party to suggest that whoever's got legal aid shouldn't have it, and you can demonstrate the fact that they shouldn't have it, i.e. that they've got a very well-paid job. That's option one. Option two is if there is also a financial matter running and the party with legal aid gains as part of the financial matter, so they get an award as part of the financial matter, the statutory charge which claims back their legal aid also claims back all of the legal aid that they have experienced in the child matter as well. So the legal aid purse is not split. You don't have a legal aid purse for finances and a separate legal aid purse for child. You have one legal aid purse. But if you gain in your finance matter, you are going to pay the whole lot back.
Then, right, gotcha. Okay, that's good to know. It's good information. Right, from Bam again, right? Yeah, I think this is the 20% guy. We went to child court and when all three hearings, will this be added?
Will what be added?
Added to what? Yeah,
A bit more clarification there.
Yeah, let me. Okay, yeah, Bam, come back with some more clarification on that and what it relates to. Right, Mr. Jar, is it a good idea to have supervised contact while CAO is ongoing before fact-finding hearing?
It's a good idea to have whatever contact you can get with your children because they're your children. If supervised contact is all that is available, particularly because there's a fact find looming, then embrace it with open arms. And I appreciate there's a cost associated with it, and that cost can be onerous for some people, and I entirely appreciate that and have every sympathy. But you need to be demonstrating to the court that your children are the centre of your world. And the only way to do that is at every opportunity say to the court, can I see my children? Can I see my children? Can I see my children?
Yes, and I like your picture, Joe. Looking good there, looking smart, looking sharp. Right, how would you go about safeguarding a new partner? That's a good question.
You don't. It's a CAFCAS exercise. You would have to flag a concern to CAFCAS that the other party, the other partner, the other parent has got a new partner that you know nothing about, and you have some concerns about the fact that obviously they are now in contact with your children, particularly if it's just a boyfriend or a girlfriend indeed, who's just sort of coming and going on dates. Yeah, but if it is a boyfriend or a girlfriend who have moved in, you then have every right to ask CAFCAS if they will carry out a safeguarding check on that individual. And of course, you also have available to you Clare's Law. It is Clare's Law, isn't it? Yeah, you also have available to you Clare's Law, which means you can make a referral to the police and ask about the details of an individual to see whether they are known to have any domestic abuse history.
Right, we are in full swing. We've got about between 12 and 15 fluctuating at any given moment. Please all like, subscribe, follow, share. Also, we have a super chat, so let's jump straight to the super chat. Right, first, Mr. J, I just want to say thank you for the super chat. This is now going to pay for my dinner tonight. I was going to go bed hungry, but you know what? This is going to get me some morsels of food tonight. So thank you. I do appreciate that. Right, and the rest of you take note here. Look at that. Take note of Mr. J, yeah? And send in some super chats, everyone, if you can. Can you explain how court assess mental health? My ex has undiagnosed BPD with self and rages. I presume self-harm and rages. What could have the impact of that be?
Your single biggest issue there, J-Dad, is the fact that you've told us it's undiagnosed. As a result of being undiagnosed, the court is going to struggle to recognise it unless it appears on medical records or it appears in terms of her behaviour i.e. you've got a series of incidents, events, episodes where her mental health is on display. It is incredibly difficult for the court because the court is not clinically qualified. So it is incredibly difficult for the court to make an evaluation on mental health. There are occasions, lots of occasions, where if mental health is flagged as a real issue and is accepted by the court as a real issue, regardless of whether it is diagnosed or undiagnosed, the court will seek expert witness advice. So they will ask for a psychological evaluation, a psychiatric evaluation, a medical evaluation, or whatever it might be. But where you sit now, just from reading between the lines, if your ex has an undiagnosed mental health issue, regardless of how that is presenting itself, you currently have something of an issue unless you can convince the court, or indeed CAFCAS, and ideally both, that mental health issue is impacting on your children, not on you. They don't care about you, to be perfectly honest, whether it impacts on your children.
I think you've got a difficult task ahead, definitely. It's not an easy one. I don't know how you feel. Difficult task ahead, that is. Right, let's go on to a positive comment. Mr. Zion. Hello, heroes. May God bless you both. Hope so this year will come full of blessings. Amen. Amen. Appreciate that for both of you and your families. I wish you both the best in your lives. We'll follow up when I see the next message. Right, another positive message. Excellent. Thanks for clarifying. Yes, it is free advice. LOL. Got to take my wins where I can. Really appreciate it, boys. Thanks. Listen, that's why we're here. That's why we're here. And Mr. Felix, everyone knows, like, a divorced guy knows other divorced men, right? Yeah. I need you to get me subscribers. I need you to spread this channel far and wide and get this information help to all of those. You must be in some fathers groups or Facebook groups. Direct them to here, Sunday night, 7 p.m. Direct them to the channel. We're here, man. We're dedicating time and energy here, yeah? So Felix, I'm glad you're taking your wins where you can. You're doing well there. Everyone should follow suit. Now spread the message far and wide.
Here.
Right. Mr. Dean, primary school disclosed what the child is saying to CAFCAS officer during Section 7 report. CAFCAS then made the referral. Nursery made their own referral to local authority.
Okay, this is back to the mother chastising the children. Then, if CAFCAS have made the referral, then CAFCAS must put some weight by it. Must be lending some weight to the allegation, or to the real incident, and that will play out in the court process. The court is decidedly uncomfortable with parents who physically chastise their children. The court regards that as physical abuse. It's not illegal in England to hit your children currently. It will certainly be in the next couple of years, but currently it is not. Bizarrely, it is the only country in Great Britain, in the United Kingdom, where it is not illegal. It is illegal in Wales to hit your children. It is illegal in Scotland to hit your children. It is illegal in Northern Ireland to hit your children, but it is not illegal in England. So it's not. But CAFCAS clearly must be placing some store by the comment, given that they've made the referral. So I trust they roll that out, play that out, because we need to bring an end to whatever that is. Children should not be being hit. It is just as simple as that, really.
Right, JDad, Mr. Cossip's got a comment on your question. To assist JDad, the judge ordered my ex's medical records, which showed a history of unattended appointments for mental health issues, but CAFCAS said in the Section 7, nothing to see here. Like I said, JDad, I think don't be negative or project any negativity. It's a difficult task ahead. Yeah. Work with what you have, present what you have. Any evidence, circumstances, or situations that you can present, which then lead to the judge saying they want a what's that thing called when they order a psychiatrist for the
Section 25.
Section 25, but there's another terminology they call it. There's a terminology they'll request a
Psychological evaluation.
That's it. Psychological evaluation. Right. So yeah, that's the only thing I can say. I don't know if you can add anything else to that, Mr. Ryan, to give him hope, but it's the only thing I can sort of think of.
Yeah, I mean, yes, you're right. Section 25 should have been ordered, but I'm just going to pick up on, and I'm going to say, is it Cozy P? Where it said, obviously, the Kafka saw a history of unattended appointments for medical health, and they said, we've got nothing to see here. I would have challenged that. I would have challenged that strongly in a rebuttal statement back to the court. You cannot just dismiss what is essentially a cycle. So, yeah, that concerns me.
All right, he's got some info here. We've got some more juice on this. Right. Thanks for evidence. I have audio recordings, texts, and diary entries referring to self due to children's behavior. What do you think?
I mean, obviously there's a whole story, J-Dad. There's a whole story behind what you're telling us. And that story, by the sounds of things, is a complex one. So it's very difficult for me to comment fully on it. But if you have audio recordings, if you have text messages, screenshots, diary entries, which are always subjective, which means because you've written them, the court should have sight of those. Kafka should have sight of those, and there is opportunities within the proceedings, without knowing the detail of your proceedings, but there's opportunity within the proceedings for you to make those known to them.
I think what I suggest, J-Dad, I think here, especially with your case, like Mr. Ryan said, there's a lot of, there's obviously quite a story behind all of this. What I suggest is you email Mr. Ryan, like it says at info@mackenziepickup.com. Maybe book a case review. It doesn't cost the earth, just to see where you're at and what hand you can play. Basically, go see Mr. Ryan, show him your hand. And then Mr. Ryan can advise on saying, you know what, these are your options. We can maybe play this hand or that hand. Maybe just book a case review with him. So look, email him, reach out to him, maybe just get a second opinion. All right, we have another super chat. Let's see what Mr. Felix has to say. A drink to go with that meal. Sorry, you'll have to opt for a soda between you. Well, Mr. Felix, I appreciate that. Thank you. But this $5, I won't get a soda. I'll go without. And I'll keep this $5 for tomorrow night, because that's where I'll get, that'll go towards tomorrow's dinner. But thank you, I appreciate that. And the rest of you, take note. Take note from Mr. Felix. He's got the best value for money advice for a $5, the amount of information that he's got, and the hope that he's got, and the belief that he's got. Mate, for a $5, come on, it's nothing. Right, just a little positive message from J-Dad. Will do. Thanks both. No, listen, that's why we're here. Reach out to Mr. Ryan. Get a coach in your corner. Right, let's go back to Mr. D. Kafka still recommending child to live with mother. And this is the chastising situation.
Yeah, so, you know, who knows? Who knows, Dean, without having a decent conversation. But there are lots of occasions where one parent, where one parent at face value is far from ideal, to be in the care of, to have the children in their care, but the court rules for whatever reason that that's still an appropriate thing to do. But it's difficult for me to comment further than that, really. But as I say, there are too many occasions where I think, oh, that's not right. But sometimes the court is faced with a dilemma, which is, you know, I've got a judge and I'm looking down the courtroom at two perfect strangers. I've got issues with the one on the left because they've got stuff that they've done which is not great. I've got issues with the one on the right because they've got stuff they've done which is not great. And I've got a call of play, which I think is in the best interest of these children. Not straightforward sometimes, not straightforward. But as I say, unfortunately, and I appreciate I'm not being particularly helpful, but without, you know, fully understanding the circumstance, I can't comment on whether I would agree with where the court is sitting on this, or whether I would entirely disagree and suggest that you challenge it. But I can't tell you at this stage.
Yeah, Dean, I think it's difficult to, without seeing the full picture, the ins and outs. Like I said, every case has little, and this is what I keep telling people, look, every case is different. every case has little nuances that make subtle changes and differences to the outcome. It is very difficult to give you something concrete. I mean, but look, the option is there. If you're still going through proceedings, you think you've got something there that you can work with, email Mr. Ryan, have a little case review, just see what weapons you have available to you and what options you have available to you, so you're just not torturing yourself, ultimately burning emotional fuel unnecessarily. So, reach out to Mr. Ryan if if we need to disclose more details, just to see exactly where you're at. Right, here we go.
Just saying, nobody buys my drinks.
Right. This is Mr. C again, Mr. Cossett. Whilst with him, you guy who I nicknamed the Tinder swindler, living in the property. Living in the property, again, nothing to see. Wish I knew about Clare's Law then. Yes, absolutely. That's a good point, actually. I sort of say before. Sorry, Mr. Ryan. I sort of say.
It's frustrating. It is frustrating when your partner presents a new face to your children. I would, thankfully, it's not a circumstance that I've had personal experience of, thankfully, but it would irritate the hell out of me if I thought of somebody else, who is engaging with my children when I am not. So yeah, I appreciate the pain.
Yep, absolutely. And I forgot what I was going to say now. All right, if it comes back to me, I'll jump on it. I've forgotten that. Yeah, sorry. This is it. Now for 2025, I think what we'll be in Mr. Ryan will try and do is also, this highlights another point. On a weekly basis, as these new changes and laws come out, now if you notice when CAFCAS was, these new CAFCAS laws were published, we covered it. Going forward, we will try and cover all of these on the Sundays when we're live, any update and stuff like that, just to keep people in the loop ultimately as to any changes in the courts, any procedures, maybe if it can be of advantage to anyone. So we're going to try and cover these things a lot more, with a lot more detail going forward, hopefully. Man, it's looking like a busy year ahead, right?
Mr. S.A. Got a court as well.
Mate, you've got loads of work to do. The way it's looking to me is sorry, let me reframe that. Looks like you've got a really busy year ahead of you, Mr. Ryan. I just have to show up. Yeah. I just got to show up. You know what I'm saying?
And you just turn up occasionally.
Yeah, I just turn up, take them super chats, try and get my dinner sorted. Right. My QLR told me for my FF that the questions I make for my ex is the only ones she can ask. But the MGM is also a witness. Do I need to prepare questions for her, but who do I give them to? Thanks again.
Okay, well, let's just deal with the acronyms first. I think we did this on the last one, but I'll do it again. FF, fact find. QLR, qualified legal representative, which is a solicitor or a barrister given to you for free by the court, who is there to ask questions on your behalf if cross-examination is going to take place in a hearing. They cannot give you any legal advice. They are effectively a mouthpiece, and that is all they are, in order to remove your need to ask the questions directly yourself. So, other part of that question, the MGM, I'm presuming that refers to the maternal grandmother. I'm going to assume I'm right on that. So the maternal grandmother, i.e. mum's mum, is also a witness, so is also going to be questioned. Who do I prepare questions? Yes, you prepare questions. I assume, and again, this will have been discussed at your PTR, i.e. your pre-trial review. I assume you have been given permission to ask the grandmother questions directly yourself. That is very normal. What normally happens is if you've got a contested hearing where you've got CAFCAS being questioned, the other parent being questioned, and another witness, regardless of who there is, being questions. It might be a grandmother, it might be a school teacher or whatever. What usually happens is you get to ask the CAFCAS lady questions because you've got no beef with her. The questions directed at the other parent are asked on your behalf, either by the judge or by a qualified legal representative, QLR. And then the other witness, be it grandmother or teacher or social worker, whoever it is, you get to ask their questions directly as well. Having said that, yes, you do need to prepare those questions. And also, you need to submit those questions in advance to the court for the judge to review, in order that the judge can make sure that your questions are relevant. We've just had another comment from SA to say the judge gave no direction in regards to the maternal grandmother. So I am telling you what will happen. You prepare questions for the maternal grandmother. You will submit those in advance to the court, in order that the judge gets opportunity to review them, to make sure that they are relevant. And then the judge will do one of two things. Well, one of three things, actually. They will either say on the day, I'm happy for you to ask these questions to grandmother, away you go. Or they will instruct the QLR to ask them on your behalf, or the judge will ask them on your behalf. It'll be one of those three, but those questions will be asked. But take my advice, prepare them and submit them to the court. Don't submit them to the other side, obviously, but submit them to the court in order that they are aware of what it is that you are trying to do. In terms of your QLR, who said that they are only available to ask questions to the other parent, I kind of disagree with that. The QLR has been made available to work with you throughout that hearing. So there really is no reason why they can't ask all the questions on your behalf. And again, and I've talked about QLRs before, depending on the friendliness, because I can't think of the word I was looking for, the helpfulness of the QLR will depend on how you prepare those questions. Some QLRs will happily let you run the first draft of questions, and they'll take a look at them, and they'll do a little bit of a tweak just to put them into some sort of legal styling, and then they will hand them back, and then they'll hand them back to you for a final view, and then away you go. Some will do that. Other QLRs who just want essentially to pick up their fee for the day and do nothing for it will just turn up on the day and say, give me your questions. And they don't care whether your questions are diabolically bad or what. They don't care. They're just going to ask what is on the paper in front of them. And that is my issue, one of my many issues about the QLR role, apart from the fact there aren't enough of them. But yeah, one of my many issues about the QLR role. But anyway, so that's where you are in the world of QLR. That's where you are with your maternal grandmother. You will very likely be asking those questions yourself. Submit them to the court first.
See, the problem is they're all just there for the money. We need that roadmap. We need people to be empowered to deal with all of this themselves directly with clarity. The word is with clarity, knowing they've got a solid foundation and the right firepower to get through this. Do you know what I mean? Without all of this headache, costing a bomb, relying on people, giving them, relying on people's friendliness. That's the point. Right, Mr. Nasser, if there's no domestic abuse proven in a proceeding in which the mother got legal aid, in the event of subsequent proceedings, say to vary the order down the line, will she still get the aids again?
If mother's got legal aid in the original proceedings, when those proceedings end, her legal aid will end. If she seeks to bring the matter, or you seek to bring the matter back to court to vary an order or change an order or enforce an order or whatever, she is not guaranteed legal aid. She has to make a fresh application in order to secure it.
Right, I just want to say, Kosip has said to Nasser, Dan's covered this in a previous live. She should not, and if she does, definitely challenge her legal aid claim. Thank you for answering that, Kosip. Appreciate you chipping in there.
Yeah, true. I'd say never be afraid to challenge a legal aid claim. Worst case, you're just going to get a bounce back that says, no, we disagree with you.
Right, the stream, right. We've been going an hour. It's on fire. Questions are coming in hard and fast. Let's start plowing through them. Right, we've got Bill Clinton here. Could temporarily changing one's gender before a divorce provide legal advantages for the husband? My personal view, I say do it. Even I'm thinking that when I enter court, I'm thinking of getting a blonde wig. Like, I'm talking straight face. Go in there saying, I now identify as a mother, period. And I'm here for access anyway. I am an NRP, but I am a mother, Please refer to me as mother. The stage I'm at, I'm literally thinking of rolling that dice and asking for my equal rights as a mother in court. So I say, do it, Bill. Let's find out. We need to try it. We need to try it, find out, and when if it works, we can start selling these blonde wigs to everyone. We need to do it. So get on it. Right, essay. Unfortunately, right.
I have
right.
no comment to make on that.
Right, I think we covered that earlier. So right, Dean Smith. Right, here we go. Has Kafka's officer overstepped the line by deciding what is true and what is not in Section 7 report? Is there a way to highlight this to the court as the court decided no fact find was needed? Good question.
Okay, as of the beginning of December, when the new when the new Kafka's domestic abuse policy was enacted, December the 8th, 9th, something like that. One of the changes that was made was removing the power of Kafka's to prejudge a matter. So removing the ability of Kafka's in their Section 7 report to essentially provide their opinion on allegations and what they think is true and what they think is not true. That is not Kafka's role. They are not qualified to assess or judge or prejudge allegations that have been made within the confines of a Section 7. They are only there to report it. So to answer your question, absolutely challenge that in court, because that is against their own policy. That is against their own domestic abuse policy that says you cannot prejudge allegations made by parties.
And he followed up with Section 7 recommendation was based on what officer decided what was true.
The officer Kafka's officers do not have the remit to decide what is true. The court decides what is true. That is the role of the judge. Nobody else in family proceedings can decide what is or isn't true.
Right, that's right. Like Farouk equals she. No, when you're in court, the word is this wording correct, mother. Not in court, I am she or her. I am mother. I identify myself as mum. Now we got a comment here from someone. Right, Rizzles 1985. How do I get my head as shiny as yours, disqualified dad? Now let me tell you something, Rizzles. Yeah. By the way, Dean Smith, Rizzles, I know, has challenged Kafkas before, and he was successful. So if Rizzles could put something in the comments to answer your question as well, give you some heads up, that would be good. Rizzle, if you could jump in here, put something there, because I know you had your dealings with Kafkas and you came out on top, a little bit on top. You know, chime in whenever you can. Right, I just want to say the reason my head is shining is because I'm a diamond. Diamonds sparkle and shine. Your head may never shine as bright as this star here, because I'm a diamond, brother. Diamond, steel.
Is that a song?
Shine like a diamond, yeah.
Yeah,
listen.
yeah.
And what you're seeing there is the sparkling, the aura that the diamond is giving off. Do you know what I mean? So yeah, there you go, right there. Right, a little positive message from Rizzles. Haha, I love you, brothers. Keep being amazing. We will. Thank you, Riz. Appreciate that. We should catch up soon sometime. Give me a bell sometime. Let's have a touch base in the new year. Right. Felix, let's say you are consistently seeing your child for almost a year. You start proceedings and then mother stops contact due to anger. Can I not raise this as an issue?
Right. You start proceedings. Yeah. You can certainly raise in court the fact that you are having a healthy contact-based relationship with your child or children up until the point where court proceedings start. And if you can demonstrate that that contact then stopped, essentially out of an act of malicious intent on the part of one parent, the court should react accordingly to that and reinstate contact. I've just done it again very, very recently. We started proceedings against mother. She then immediately killed all contact with the dad. We put ourselves in court. We raised that in court. Dad saw his children the next day.
Okay. Right, Mr. Ryan, while Rizzles is giving some info there to Dean, I've got a question from Instagram, yeah? So let's try and pick up on this. In summary, what are the main legal advantages a resident parent has with a lives with order, i.e. taking the children out of the country, etc.?
taking the children out of the country, if you've got a live with order, you are entitled, if you are the parent who has the lives with order, you are entitled to take your children out of the country for 28 days, no more, but for 28 days, and you do not require the permission of the other parent in order to do that. You have the court's permission to do that.
Right, okay. Right, someone just messaged me on WhatsApp saying, you look very downbeat during the last few podcasts. Did I look downbeat on the last podcast?
I think you look very down. I thought we were very jolly the other day when we were doing it on whatever day it was, Wednesday.
I'm feeling pretty good today. Like, I don't know where this is coming from. Am I giving the wrong vibes here? Like, what's going on? And someone said to me, I'm rocking my chair too much. I agree. I'm very fidgety because I'm energetic. Yeah. I've been to the gym. I've been pumping iron. I've been pushing it. Do you see what I'm saying? I'm chasing my gold. I'm taking things to another level.
Yeah,
I'm full of beans, bro. Do you know what I'm saying?
Yesterday and today, haven't you, mate? Yesterday and today, you've been to the gym.
Yeah, and the week before that. Listen, this is It's going to be consistent. Listen, this will be consistent. I'm pushing it. Right, listen, these questions are coming in hard and fast. Right, let me try and bang out a few more. Right, in 2025, I would love to see these third-party domestic abuse charities held to a higher account in child matters, as from my experience, they have far too much liberty to put things into print, which are totally unsubstantiated. Here's hoping.
I take that point actually, and I agree with you to a point with that. Yeah, the problem is when we follow the textbook, and there is a textbook. Let's not kid ourselves. When we follow the textbook, it does say rush off to Women's Aid or rush off to New Era or rush off to one of the domestic abuse charities, and they do, and I appreciate why they do, but they take that parent at face value. So you walk through their door and say, "I'm an abused woman." They accept it because why would they not? Why would they not? And the problem is that then they suddenly decide to start writing stuff down and providing expert opinions on it. And that's where I've, on too many occasions, and I have absolutely no issue with domestic abuse charities. I think that essentially they're a wonderful thing. But I have challenged domestic abuse charities on more than enough occasions to say that their expert opinion, there's nothing expert about it. It's the opinion of one individual, unqualified, talking to another individual who is potentially lying or potentially not. But we can't provide that as an expert opinion. So I take the point. I do have some issues with the domestic abuse charities. I think sometimes they do overstep the mark. I appreciate in a situation of real domestic abuse where a party is being hurt, physically, mentally, emotionally, sexually hurt, then the work they do is fantastic. But occasionally, I have an issue with them.
Right. Excellent. Thank you. What is Dan's firm called? Very important question, Mr. Ryan. What is your firm called, and how can people get a hold of you?
On the bottom of the screen, let me just see. On the bottom of the screen, that's my email address, info@mackenziepacave.com. Mackenzie Pacave is the name of my practice. We've got a team all over the country. We've got new people joining us pretty much all the time. But there you go, mackenziepacave.com. That's the website, info@mackenziepacave.com. That's where you'll find me. By all means, drop me a line.
Right, we've been going 1 hour 15 minutes. I'm going to call this the final question of the night before we try to conclude. Right, Mr. M, I've got my first joint mediation session coming up with a high conflict mom. What should I look out for? Any thoughts, comments from you guys? Big thank you to both. This is a very good question, I think. Yes.
Very, very good question. The court is getting very, very hot on mediation. The court is wanting to encourage mediation primarily, and let's be honest, primarily because it pushes the matter back out of the court for a while. It may not achieve anything, but at least it kicks it out of the court and gets it off the court's list for a while. Perhaps I'm a bit cynical in that, but that's probably the reality. But anyway, you're going into a joint mediation session with what you describe as a high conflict mum. There is a possibility that your mediation will be conducted using a method called shuffle, which means you're in two separate rooms or on two separate screens, so you don't actually see each other. what you are essentially looking out for is the allegations that she is going to throw into the mix. And let's not kid ourselves, she is going to. So you're looking out for those and challenge them, address them as they come out. But I also say this, and this is perhaps going to be a surprising comment. If the allegation is true, say so. And we do, all of us, men, women, children, we do occasionally behave inappropriately. So if the allegation that is being made against you is true, tackle it, admit it, accept it in order to settle it. Because otherwise it will get bigger and bigger and bigger, and eventually it'll end up in a family court, and then you will start to look awkward. So challenge if you feel you need to challenge, but let's be grown-ups, let's be real men, let's be real women. If it's true, yeah, I did that, I'm not proud, I'm not happy, I'm very uncomfortable with the fact that happened, and I'm sorry, but I did it.
Right, I just want to add to that about mediation. I mean, correct me if I'm wrong, Mr. Ryan, but you're aware of a certain firm that now does mediation, aren't you? I'm sure. Mackenzie Pickard now do mediation or have the license to carry out mediating services. So
we do. Yeah, we have a mediation product in house. So yes, we carry out court-approved mediation within the confines of this practice. So yes, we do. Yeah, that's very true.
See, look, we're not here to scout official business. As you see, Mr. Ryan is not even doesn't even highlight this stuff. But look, he does he has got a license, he does mediation in-house. So reach out to him if you can use him. Use Mr. Ryan's mediation service. And Mohammed, sounds like you are at the start of your journey. Obviously, if you would like Mr. Ryan to represent you or his firm to represent you, reach out to him, have a chat, just give him the details of your case, see where we can go, get ahead, and get ahead while you can, get the relevant information and the right people in your corner. At this stage, it's a crucial stage ultimately.
It is. If you're at it doesn't matter where you are in your journey. There's always room, and I say this to all my clients all the time. I say I'm not precious. If at any point in your journey you feel you want to get a second opinion from somebody else, and in your case that second opinion might be me, but in my client's case that second opinion might be somebody else, I'm not precious about that. What I'm precious about is that we arrive at the end of this journey with a fair outcome for everybody involved, particularly the children. How we get there, I'm pretty flexible about. And to answer Felix's comment, yes, Felix, we do family mediation and we also do financial mediation. So,
yes, you heard that. Family and financial mediation, the whole divorce, start to finish, A to Z mediation. We got solicitors in house, we got barristers in house. We can bring out firepower as and when needed. And I'll tell you what I'm passionate about, what I'm excited about. I want to talk about this roadmap. Right, we're going to take no more questions and comments. We've been going for an hour, 17 minutes straight. I think we've had a good run. Let's try and move towards a conclusion, and something that me and Mr. Ryan want to talk about. Obviously, Mr. Ryan, we mentioned on Christmas Day the studio. We've got a new in-house studio that we're going to be making some content from and launching more projects from there. Also, there's a Facebook group that you wanted to talk about. So just touch on that as a little bit before we wrap up for the night.
Okay. Yes. So myself and Farouk have invested in a studio setup called Arch Studios. That'll be going live in the next couple of weeks. It's a fully dedicated broadcast space, so full light rig, cameras, blah, 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 in order that we can start to produce some very high-end quality broadcasting. And that'll be live broadcasting the way we do now, but also recorded material. I'm going to produce over the course of the next few months, and then that'll just carry on. I'm going to produce a series of what I'm referring to as soundbite lectures. So they'll be 2 or 3 minutes long, 4 minutes long, no more than that. And I'll be taking a very specific subject, like possibly mediation, like possibly QLRs, what's a QLR, and I'll be dealing with it in 3 or 4 minutes in a soundbite lecture, and then there'll be however many dozen of those, because there's lots to talk about, which will be coming out. So they'll all start to fall over the course of the next few weeks and months. Also, what else is happening in that particular world is that myself and my learned colleague over there are going to launch a new product. And it's probably going to be February, March, I think, if we're being realistic as to when it's going to hit the market. But we are excited about it. We've touched on it a few times in the last few broadcasts, mentioning this need for a roadmap and talking about, wouldn't it be great if a litigant in person could find their way through the family court system without having to rely upon expensive legal support, or indeed, I mean, we're not cheap. Let's not kid ourselves. Or the use of experience, but still a cost associated. Mackenzie friends, imagine if you could get through the process entirely alone. In order to do that, as a litigant in person, you need an education, and you need an education that you can run alongside your proceedings. And so that's what we're going to do. Tell them, Farouk.
Absolutely, absolutely. And listen, along with this, you will still have the support of myself and Mr. Ryan, weekly workshops, and with multiple other people who are going through the journey, and we will pick up, like I said, we will support you through that journey. So you will have the roadmap, you'll have the GPS, you'll have the sufficient knowledge and information to carry you through this journey, along with direct contact, live workshops, live support, physical, mental, emotional support, legal support, and knowledge. And like I said, we have barristers and solicitors at hand for additional firepower, so we can bring in even that knowledge as and when required. Like I said, everything has a place. So it's a one-stop shop at a fraction of the cost to get you the best possible result without going broke, because like I said, the next stop is you completely alone trying to go through it, which is still not a good idea. You'll never know at the end of your proceeding if you could have, what chance you had. This is the first stop, first tier, sort of, from a cost perspective, route that you could take, which gives you a solid foundation and a good chance of the best possible outcome with the least amount of money spent ultimately. And we want it available to the masses. The biggest change we can bring is get that information out there to the masses ultimately, alongside what we're already doing. And that will eventually, hopefully, bring a changing trend in the outcomes of family court. Because the problem with family court is, remember this, the knowledge and information is not out there. The most information, as far as I'm concerned, out there on the internet is what's out on disqualified dads. Ultimately, the work that myself and Mr. Ryan have done, as far as the nuts and bolts, the nitty gritty, raw information in layman's terms, right? Explained from many angles. This is the most information that I've known out there on the internet, and even from when I was looking for this information, it wasn't there. This information is not there, so we're going to make it available and accessible. But unfortunately, with most of these things, it takes time and energy to create, and there will be a cost associated with it. But it will be nothing like, it's not high end, as in solicitor, barrister, not even Mackenzie level. It's a tier below. So you'll have the support, the knowledge, without someone sitting there with you. You're doing it alone, but we are there we are there behind the scenes to provide the information and support. It's happening. 2025, it's going to happen. It's as simple as it's getting out there.
It is going to happen, and I appreciate that myself and Farouk have been deliberately quite vague about the roadmap, about what it specifically is. But that's primarily because obviously it is a commercial product. It does have an intellectual property element to it. So we're having to be vague at the moment, but it as I say, will come in the first quarter of this year. I think, particularly having worked in family law for years now, I think it is arguably the most exciting thing to happen for litigants in person in years. That's the value that I place on it. So that'll be coming out. Farouk also mentioned Facebook. We will be launching a Facebook group that kicks probably in 7 to 10 days time. To be honest, my techies are so weighed under at the moment with a whole series of issues. But we are going to launch a Facebook group that'll come out, which will link disqualified dads with Mackenzie McCarve. It'll be open to anybody to join, and it'll work very similar to this stream. That you can pop questions in there, and we will, me and my team will answer those questions. We'll tackle the questions that are revolving around the world of coaching. And we'll just make ourselves available. There are already some very good family law Facebook groups, some very good ones. I'm going to join a number of them over the course of the next few weeks, and I'm doing that probably just to make people aware of the fact that we've got one. But it's a real world. But yeah, so ours will go live. We'll keep you advised as to when that's going to happen over the course of the next week to 10 days. We'll be encouraging everybody, obviously, to join it. We'd like that to rack up to a significant membership count very quickly, because the information that is going to be on there is going to be invaluable. We will be answering questions. I will be also lodging the soundbite lectures on there, as well as on YouTube. So we'll be making information available to people. And
yes,
that will irritate the legal community, but oh well.
Exactly. Like I said, these soundbites information will be available. Like I said, Mr. Ryan's got a YouTube channel. Go over there and subscribe. I keep trying to point towards it, but he spends more time on his channel. So look, all information will be on all channels across both platforms, Mr. Ryan's and mine. So it has a further and wider reach. And 2025, like I said, look, guys, this stream, just so you're aware again, we'll be here every Sunday, 8 p.m. every Sunday. We aim to be here. Doesn't matter where I am, I'm going to be dialing in. We're going to be hitting this. And and hopefully another midweek session we're going to start bringing in for coaching and just to how to manage the emotional side of it and how to generally improve yourself in life. So, hopefully you don't end up in this situation again. So look, plenty happening, plenty more coming. Like, subscribe, follow, and share. Thank you all for taking part and engaging. I appreciate each and every one of you, and we shall see you next week, 8:00 p.m.
See you, folks. We'll see you next week.